Welcome to This Explainer. Today, we're diving headfirst into the absolutely fascinating 150-year evolution of the Nigerian legal system. We're going to trace its incredible journey from organic, community-based traditions all the way to the highly complex, pluralistic, modern framework that's operating today. You know, when you look at the legal structure of a nation, you're really looking at the history of its people. And Nigeria's story, well, it's one of profound collisions and just remarkable syntheses. We're drawing our insights today straight from the academic materials of the National Open University of Nigeria. Specifically, we're looking at their course material for Law 212, Nigerian Legal System 2. This text gives us a fantastic objective lens to really understand how centuries of custom, decades of colonial rule, and the deep, deep roots of Islamic law all converged into a single national system.
Here's a quick look at our roadmap for today. We'll be moving from the deep roots of customary law through the colonial era, all the way to today's modern judicial setup. So let's jump right in. Section 1. Roots of customary law, the living law of the people. So it's a super common misconception to view pre-colonial societies as somehow lawless, just because they didn't have brick-and-mortar courts. In reality, order was maintained across hundreds of ethnic groups through really effective social mechanisms. Customary law wasn't some rigid statute passed by a legislator. It was an organic, living law. It grew directly out of the people's history and their daily habits. Essentially, it was a code of conduct people set for themselves voluntarily, and they obeyed it under the threat of societal censure or community pushback. Because customary law wasn't, codified in a textbook somewhere, it was incredibly dynamic and elastic. It adapted to societal changes rather than being frozen in time. For instance, think about the concept of family land. It naturally evolved from being strictly inalienable, meaning no way could it ever be sold outside the family, to eventually accommodating modern sales and transfers as economic realities shifted. It was a true reflection of whatever the community's accepted usage was at any given moment.
And this flexibility meant different regions essentially governed themselves in completely unique ways, perfectly adapted to their distinct social structures. Up in the north and west, you had chiefly societies. These were centralized, authoritarian structures where judicial power was strictly tied to territory. But then, in stark contrast, the east featured chiefless societies. These were decentralized, very egalitarian, and relied heavily on kinship and lineage bonds. Yet despite these massive differences, the fundamental purpose of the law, maintaining social equilibrium, was exactly the same across all these autonomous groups.
Section 2. Proving unwritten rules. Bridging the gap to formal courts.
This brings up a really fascinating question, right? As Nigeria transformed into a modern, heterogeneous state, how do you actually prove a law exists in a courtroom if it has literally never been written down? Well, the burden of proof lies entirely on the person claiming that the custom exists. Courts follow a pretty clear procedure here. They rely heavily on the community's traditional custodians, bringing in expert evidence from leaders like obas or emirs, or taking testimony from credible witnesses who are intimately acquainted with the tradition. And if a custom is proven successfully and frequently enough, the court eventually takes what's called judicial notice of it. That basically means everybody agrees it's real and it no longer needs to be proven from scratch in future cases.
But here's where the tension really kicks in. Even if a custom is undeniably proven to exist, and even if it's universally accepted by the local community, it still has to pass some incredibly strict validity tests before a modern court will actually enforce it. Most notably, a custom must pass the repugnancy test. This means it cannot be repugnant to natural justice, equity, and good conscience. Plus, it absolutely cannot be incompatible with any currently binding formal statutes or contrary to public policy. It's a high bar to clear.
Section 3. The colonial legal collision. Picture this. You have this organic, community-assented legal system, carefully built over centuries. And suddenly, bam! It collides head-on with the arrival of British colonial forces. The year 1863 marks a massive turning point. A totally foreign, highly technical legal system was superimposed right on top of indigenous practices. The British wanted to replicate their own system in the colonies, so they introduced the common law of England, doctrines of equity, and sweeping statutes of general application. Actually, scratch that. It wasn't just introducing them, it was essentially dropping blanket laws designed for English society straight into Nigerian courts. Local customs were sidelined, only recognized if they managed to pass that English test of repugnancy we just talked about. This collision revealed a massive clash in core philosophies. Customary law was fundamentally restitutive and reconciliatory. The whole goal was to restore harmony to the community. So, for example, rather than locking an offender in a cell, a customary court might compel them to work the victim's farm. Make things right, you know? The British system, on the other hand, brought in a rigid, state-driven punitive approach. It was essentially a tariff system where the state and the offender were the primary parties, and the actual victim, they were often reduced to just being a mere witness in the proceedings.
Section 4. Customary versus Islamic law. To add a whole other layer of complexity to our explainer, we have to talk about Islamic law, particularly the Maliki school brand. This had already profoundly shaped the legal landscape in the northern states long before the British ever arrived. When you put these systems side by side, you see some stark differences in their internal logic. For instance, under customary and British common law, intoxication might actually serve as a partial defense for a crime. But under Islamic law, intoxication is not a defense at all. It's considered a crime in and of itself. The personnel dispensing justice also shift dramatically, moving from traditional elders and kings to learned Islamic scholars and qadis. Now, unlike those flexible, ever-changing, customary habits we talked about earlier, Islamic law is built on highly structured written foundations. Because Islam is regarded comprehensively as a complete way of life, its legal system acts as the supreme law for its subjects. It draws its authority directly from sacred written texts like the Holy Quran and the Sunnah, and it combines those with the scholarly consensus of ijma and the analogical deductions of qiyas. It provides a very firm, definitive legal framework. Section 5. Modern judicial synthesis. Let's see how all of this comes together.
So, how do all these colliding historical forces actually synthesize today? Well, modern Nigeria doesn't just pick one of these histories, it has to manage and balance literally all of them simultaneously. And as you can imagine, that creates dizzying complexity for modern judges. Just imagine a bustling urban center where a judge has to carefully determine which specific law applies to which specific transaction. For example, entirely different laws and consequences apply depending on whether a marriage was conducted under Christian statutes, Islamic law, or customary tradition. It's a maze, and the overriding consideration in navigating it is always the interest of justice. To keep up with this rapidly changing and incredibly diverse political landscape, the court system had to constantly adjust its architecture. Starting way back with the early consular courts established for colonial trade in 1863, the system evolved to create protectorate courts, eventually adding high and magistrate courts in 1993. This constant institutional evolution just kept going, right through Nigeria's independence in 1960, all the way into the modern era with the 1999 Constitution.
And that brings us to the final synthesis, a modern constitutional structure that actually institutionalizes all this diverse history. At the federal level, you have the Supreme Court, the Court of Appeal, and the Federal High Court. But at the state level, the Constitution builds dedicated courts like the Sharia Court of Appeal and the Customary Court of Appeal right into the fabric of the state. This ensures that the rich, deeply varied legal traditions of the Nigerian people are respected and maintained within one unified national system. It's really quite brilliant when you look at it.
To wrap up this explainer, I want to leave you with a final, kind of provocative thought. We've seen how formal statutes and living customs have collided and synthesized over the last 150 years. But as society continues to rapidly evolve, it begs the question, when pushing for social change, which law truly governs the daily lives of the people? Is it the rigid text written in the Constitution, or the organic, living law breathing within the culture? It is a fascinating balancing act, and understanding it is absolutely key to understanding the Nigerian legal system. Thank you so much for joining me, and I'll catch you in the next explainer.